Namaskar. In the first part of this discussion, we saw how the girls demanding to lift the ban on hijab in Karnataka schools and how the state government argued and counter-argued in Karnataka High Court. And we also saw how Karnataka government justified this ban. In this part, we'll discuss what happened in Supreme Court of India, what was the argument and counter-argument in the Supreme Court, and how the split verdict was given by the Supreme Court of India. So now when these girls challenged the verdict of Karnataka High Court in Supreme Court, their argument was almost on the same line on which they had argued in Karnataka High Court. Their lawyers said almost the same thing, that the ban on hijab is violating their fundamental right of religion under Article 25. This is also violating their fundamental right of free expression through hijab under Article 19(1). It is also violating the fundamental right to privacy, that is right to life under Article 21. This ban is also violative of their fundamental right of equality before law, as well as the fundamental right of non-discrimination by state on the basis of gender. These two rights under Article 14 and 15 of the Constitution of India. Of course, the advocates of these girls also refer to certain other materials, certain other references, certain other sources and resources. They also quoted certain other verdicts of Supreme Court of India and High Court of India. They also discussed or mentioned certain portions and parts of the debates which had taken place in Constituent Assembly when the Constitution was being framed. And they tried to establish the point that this ban is illegal, unlawful and unconstitutional. They try to prove it through all these points, the previous arguments, and also with some new arguments, or rather new references and new materials. But they wanted to establish the same points, that this ban is violating all these fundamental rights which we discussed earlier. Now, state government also, through its law officers in Supreme Court of India, they also took almost the same line which they had taken in Karnataka High Court, that hijab is not an essential religious practice, so it is not violating the fundamental right of religion under Article 25. They also said that there is a caveat that reasonable restriction can be put on this right to religion in the larger interest of public order, to maintain public order, to maintain public health, public morality, and to protect other fundamental rights. And they also said that in fact allowing these girls to wear hijab means other boys or other girls are being, their rights of equality is being violated. Rather, they said this thing. So they also said that these Article 14 and 15, equality before and gender discrimination, as well as the freedom of expression and the right to privacy under Article 19 and 21 respectively, which these girls had argued that these rights are being violated. The state government said that not at all. To say that these rights are being violated is completely out of context. These rights too have certain caveats or certain expressions attached to these rights under the same article, that certain reasonable restrictions can be put on these rights also in the larger interest of national integration and some other condition and circumstances. So this ban is completely a reasonable restriction on these rights. So everything is fine and this ban is good in law. Karnataka state also, through its advocates, mention or they refer to various other materials, various other Supreme Court judgments, various other High Court judgments, They also referred to certain portions of debates and discussions which had taken place in Constituent Assembly. So in totality, these were the arguments and counter arguments. In fact, the state government also mentioned Dr. Bhimrao Ambedkar's statement in one of the debates in the assembly that time, that when we talk about the religious practices in the fundamental right to religion, we mean here the essential religious practices. And the state government said that nowhere it is being established that hijab is an essential religious practice. So on the basis of these arguments and counter arguments, then both the judges of Supreme Court, Honorable Justice Gupta and Honorable Justice Dhulia, they sat to give the verdict. Justice Gupta, before giving his verdict, beautifully explained the concept of secularism, the true secularism in this country, the concept of religion. He also referred to certain sources of the personal law of that religion, in which hijab is a matter of importance, as is being said. He also quoted something from Surah and certain other authorities' books on that particular religion. Then on the basis of all those things, Justice Gupta said that he is completely agreeing with the verdict of Karnataka High Court that this ban on hijab in schools by Karnataka government is completely justified, and it is not at all violating any fundamental rights of these girls, and it is a form of reasonable restriction on the fundamental rights. So he said that he is agreeing with the Karnataka High Court verdict. Whereas Justice Dhulia completely differed. He said that he is setting aside the Karnataka High Court verdict because he said 3 points. First, he said that Karnataka High Court should not have gone into the debate of whether hijab is an essential religious practice or not. He said that only these 2 facts, that is the fundamental right of expression through hijab and the fundamental right of privacy, these 2 rights, or the discussion on these 2 issues or these 2 rights, fundamental rights under Article 19 and under Article 21 was enough to resolve this issue. The third point he said, and then he also said that on the basis of his view on these 2 fundamental rights, he said that this ban on hijab is completely violating these 2 fundamental rights of these girls. Then he said that even if when we talk about the Article 25, which provides the right to religion, he said that in that Article 25, the expression essential religious practice is not mentioned, it is only mentioned religious practice. So he said that hijab is a religious practice, a simple religious practice of these girls, whether essential or not doesn't matter, and if a ban is imposed on this simple religious practice, so it is violating their fundamental right of religion under Article 25. Further, Justice Dhulia also said that these girls with great difficulty had come to school for education, so we must allow them. What's the harm if they are entering the classroom with their hijab? He also referred to certain verdicts of Supreme Court of Africa and also Supreme Court of the United States of America, and also certain verdict of the Indian courts in support of his verdict and statement. And ultimately he said that he is setting aside the verdict of Karnataka High Court. So this is all about what happened in the Supreme Court of India and how the split verdict was given. Now the situation is that this split verdict, because of this split verdict, this entire matter has been referred to Chief Justice of India, who would form a larger bench, maybe of 3-judge bench or maybe of 5-judge bench, and then hopefully this matter would be resolved. But now, with all the respect, regard and a feeling of dignity towards Justice Dhulia, I must say that his verdict, his opinion has raised several questions in the minds of the people of this country, and these questions are such questions which might have larger impact on society or the way the governance of this nation will take place. But we'll discuss all those larger questions, serious questions, deeper questions in the next part of this discussion. The last part, the third part, it will be the last part of this entire discussion. And I hope you like this video, this discussion, this analysis. I thank you very much, and I request you to please subscribe this channel and also put the like button of this video, of course, if you liked it. Till I come with the third and final part of this discussion, till then, I thank you very much. Please have a great time and good luck to you. Thank you.